Okay, class, we're moving on to chapter, we get in the camera, we're moving on to chapter 19. For now, we're going to skip 16. We're going to come back to chapter 16 after chapter 19. The reason for this is because chapter 19 deals with agency relationships. Chapter 16, we will start to get into the forms of business, such as corporations and sole proprietorships, etc. I believe that it's important for you to know a little bit about agency relationships before we talk about the particular types of businesses. Okay, so the restatement has a rather convoluted or very extensive definition of an agency relationship, and you can read that from the screen. But basically what an agency relationship is where one person authorizes another person to act on their behalf and the other person agrees to do so. It's called a fiduciary relationship, and that's a very important term in the legal system. A fiduciary relationship means that the parties owe a very high duty to one another, a duty of a very high duty, one that is no conflicts of interest, loyalty, etc. We'll get into that a little bit more later. Okay, so right here, it's a fiduciary relationship that involves trust and confidence. Now, agency relationships can exist in employer-employee relationships and other types of relationships. For example, you all are aware of the power of attorney, where one person allows another person to act on their behalf, and we'll be talking about that a little bit later. But the most common is the employer-employee relationship, which is an agency relationship. And the person who authorizes another to act on their behalf is called the principal, and the other person is called the agent. And one of the most important things to recognize here is that virtually no businesses today could operate without agents, without employees. And so it's important to understand that concept. Okay. Now, we're going to distinguish between an agency relationship and an independent contractor relationship. Okay, and this is very important, and we're going to get into some detail on this. In an independent contractor situation, the person doing the work for the other person is not an agent of the other person. Okay, they're what we call an independent contractor. Now, the most significant difference between agency relationships and independent contractor relationships is, or one of the most significant, is the fact that under agency law, the principal is liable for the acts of the agent performed within the scope of the agency. In other words, if the agent is acting within the scope of what was expected for them to do, and they do something wrong, like a tort, a negligent act, the principal is responsible for that. In an independent contractor situation, that's not true. The person contracting with the independent contractor has no liability for what that person does. To put this in a really good context of a contemporary situation, let's look, and I believe it's in your textbook, at Uber and Lyft for that matter. When I first heard of Uber, and it was explained to me what Uber was, the first thing I thought of was, it's going to be an agency issue. Why? Because Uber started off, at least, taking the position that their drivers were independent contractors. Why did they want to do that? Well, first of all, to not be responsible for any of the torts of the drivers. Second of all, under law, they're not responsible for withholding taxes. They're not responsible for withholding Social Security because it's not an employee. They don't have to have workers' compensation. They're off the hook for a lot of responsibilities that employers have. Well, right now, that is a big controversy all over the country. Courts have ruled in some instances that it is an agency relationship. Most of the time, at least a year or so ago when I researched this, it seemed like Uber was trying to avoid court rulings on it by simply paying litigation costs or paying off the who's suing them in order to avoid a high court ruling that would make them actually be treated as an agency relationship. Now, how do we tell the difference between what one is and what another one is? And that's one of the problems that exists under the law, because there's no definition. The courts have adopted a test that they use where they look at various facts of the relationship and try and decide from those facts whether or not it's an independent contractor or an agency relationship. What are those criteria? Number one, and these are not in any kind of order of importance. All these are taken into consideration and weighed. How much control does the employer exercise over the details of the work? Is the worker engaged in an occupation or business distinct from that of the employer? Is the work usually done under the employer's direction or by a specialist without supervision? Does the employer supply the tools at the place of work? If the employer supplies the tools, then it's likely an agency. If the worker supplies the tool, then it's likely an independent contractor. Okay? For how long is the person employed? The longer the employment, the more likely it is to be an agency or an employer-employee relationship. The shorter the work, the more likely it is to be an independent contractor. What's the method of payment? Is it a time period or completion of the job? If it's completion of the job, it's probably an independent contractor. If it's a time period, it's probably an employee or an agency relationship. What degree of skill is required of the worker? The more skill required, the more likely it is to be an independent contractor. So as I said, the decision affects the liability of the principal or of the person hiring the worker. Take, for example, another good example that I like to use is somebody who owns an apartment complex. Let's say they have 25 units that they own, that they rent apartments. Okay? If they have a handyman that they pay X amount of dollars a week to fix things around the apartments that the handyman can fix, that handyman is an employee. On the other hand, and let's say somebody's toilet is leaking, and they call the owner, and the owner sends the employee out there to fix it, and he fixes it. That's an employee or agency relationship. But if they call a plumber, and the plumber comes in, and the plumber has his own company, then that's going to be an independent contractor. Copyrighted work created by an employee is usually owned by the employer. However, copyrighted work created by an independent contractor is not going to be is not going to make the contractor, the person who contracts for the work, the owner of that property most of the time. And that can be critical in situations because of the royalties that one receives for that. So generally we can say that agency relationships are consensual, they require no consideration, they require the principal to have contracted capacity, and can be created for any legal purpose. Talked about Uber and Lyft, that's on page 48 of your book. Now, if it's an independent contractor, as I said, the employer doesn't have to pay taxes, Social Security, no workers' comp, unlikely any liability on the person they're hiring, and not subject to minimum wage. Now let me mention something that's often not understood by people, but when you get paid and you're working as an employee, as an agent, you get your check. When you look at your check, the employer's going to put on the check an amount that was taken out for Social Security. Okay, the amount that you're paying in Social Security out of your wages is going to be 6.5%. But the actual amount of Social Security is 13%. The employer is paying the other 6.5%. When you are an independent contractor, you have to pay Social Security directly, and you have to pay the full 13%. So if you're looking at a job, and I used to tell this to paralegals all the time because lawyers like to oftentimes hire paralegals as independent contractors. If you're an independent contractor, you need to get paid more than you would as an employee because you're going to have to pay that 6.5% extra for your Social Security, in addition to these other issues. So we're going to stop there, and we'll pick up with part 2 in the next video.